The Supreme Court in a landmark judgment has upheld by a 3-2 majority the Constitution 103rd Amendment Act 2019, which introduced the 10% reservation for economically weaker sections in higher education and government jobs. The majority judges said that the reservation is an instrument not only for inclusion of socially and educationally backward classes to the mainstream of society, but also for the inclusion of any class or section so disadvantaged. While the dissenting judges, which included the Chief Justice also, they said that this EWS quota is contradictory to the essence of equal opportunity and strikes at the heart of the Equality Code. Let us first understand this 103rd Amendment Act. This EWS reservation was granted on the basis of recommendations of a commission headed by Major General Retired S.R. Sinho, brought through the 103rd Constitutional Amendment Act 2019. In 1990 also, the VPC government tried to bring a constitutional amendment to provide 5% or 10% reservation for individuals who are economically poor without any reference to caste. But the opposition did not support it. Again, then the P.V. Narasimha Rao brought a 10% reservation in government civil posts for economically backward sections. However, this was struck down in the Mandal Commission case, where the Supreme Court said that Constitution does not provide for reservation for any individual on economic or poverty basis alone. Finally, in 2019, 10% reservation was given to economically weaker sections other than backward classes, scheduled caste and scheduled tribes in higher educational institutions and government jobs. Amendments were brought in Articles 15 Clause 6 and 16 Clause 6 of the Constitution that deal with the fundamental right to equality. Article 15 deals with prohibition of discrimination on grounds of religion, race, caste, sex or place of birth, while Article 16 guarantees equal opportunity in matters of public employment. Several amendments were made to provide special laws providing reservation for backward classes, scheduled castes and scheduled tribes. So Article 15, Clause 4, Clause 5 and Article 16, Clause 4 covers socially educationally backward classes, other backward classes, OBCs, scheduled castes and scheduled tribes, giving them benefits of reservation. The new amendment empowers the state governments to provide reservations on the basis of economic backwardness, and it is determined by criteria such as land size owned, annual income, etc. The criteria are: annual income should be less than 8 lakh rupees. The person should not own more than 5 acres of farmland. People who have a house but less than 1000 square feet in a town, residential plot of less than 100 square yards in notified municipalities, and residential plot of less than 200 square yards in areas other than notified municipalities. This criteria has been fixed for EWS reservation. Now, why it was challenged? This amendment permits the state to make special provisions including reservation based on economic criteria. Already Supreme Court had struck down reservation on the basis of economic criteria in the 1990s. By permitting the state to make special provisions in relation to admissions to private unaided institutions, and by excluding the socially and educationally backward classes, OBCs, STs from the scope of EWS reservation, it said that it goes against the equality of opportunity, it hampers the basic structure and goes against the fundamental right to practice a profession. Because this EWS reservation excludes the classes that are covered under other reservation, it just includes economically weaker section. The case was brought in the Supreme Court. However, in its judgment, Supreme Court said that it does not hamper the equality of opportunity, because since equals cannot be treated unequally, therefore unequals cannot be treated equally, and since OBCs, SCs, STs are already covered under the reservation and they are treated differently, so here they cannot be treated equally with EWS. It also does not go against basic structure, because in a way it balances the non-discriminatory compensation and provides reservation as a way of affirmative action, and a general rule of equality cannot be treated as a basic feature, so it does not go against the basic structure. Judges also said that treating economically weaker section of citizens as a separate class would be a reasonable classification. It could not be termed unreasonable or unjustifiable classification, and therefore is not violative of Article 14. However, the judges said that reservation should not continue for an indefinite period of time so as to become a vested interest. It should be reviewed, and And backward class members, those who have attained acceptable standards of education and employment, they should be removed from the backward categories so that attention can be paid towards those classes which genuinely need help. So this was all about Supreme Court judgment and 103rd Amendment Act. See you in the next video. Thanks for watching. Have a nice day.